Well, good afternoon, and welcome to our lecture for week three, Human Resource Management, course 316, Employee Selection and Staffing. Uh, in my response to you last week regarding your postings for So What's Affirmative Action case study, and why Supreme had to complete and have a affirmative action plan on file. Some of you alluded to the tenets of that are outlined by the Supreme Court on page 85 in the text, and which talks about affirmative action. But those tenets that you mentioned specifically address the Supreme Court case Kaiser versus Weber versus Kaiser Aluminum. And the issue here is that when that particular case and many other particular cases of affirmative action that are address private enterprises, those companies that do not have a contract with the federal government and or are not a federal contractor, those are different. And so we need to look at, in some cases, what the requirements are for companies that have contracts with the federal government, starting as low as $10,000. And also, they're going to have to do things with their own subcontractors as well. As you know, and I'm going to come up with a different reference here tonight, a textbook that I'm going to be switching to, titled Staffing Organizations by Henneman Judge and Kammermeyer Mueller. And I'll sum up what they have to say at the end of this. But it's important that we go over what is required. I'm on the wrong thing here. It's important. I apologize. I didn't realize had my telephone set up instead of through the PC. You really didn't miss very much. I'm talking about the difference between a voluntary affirmative action plan, such as the one that was entered into between, or the Supreme Court mentioned in the case of Weber versus Kaiser Aluminum. Kaiser Aluminum in this particular case was not a federal contractor, and so its affirmative action plan falls under different parameters, as the Supreme Court pointed out. And as I mentioned in your responses, some of the responses I received last week, several of you picked up on the voluntary portion, which is listed on page 85 in the text, and refers to, pardon me, what was decreed in Weber versus Kaiser Aluminum. And those are voluntary plans that are much different than a plan that is required from a federal contractor. Now, having said all that, and I just mentioned before, I'm going to sum this up with 15 or 20 minutes that I'm going to speak here about this before we get into some more things about federal law, et cetera, and then the discussion of the Griggs case tonight. We're going to, I'll sum up and use this book, Staffing Organizations by Henneman, in its 8th edition. It's a text that I'm going to be switching to next year, at least switching to augment what we have now. I've found something a little bit better. I have a little bit better PowerPoint slides and a few other things, so I'm going to do that. And I apologize that I wasn't able to get that for this course. Not that I don't like the current text that we have. It's good. It's a good practical book, but it doesn't have PowerPoint slides. And the PowerPoint slides that I do use come from a human resource management text that I've used in the past to teach human resource management. And now I'm going to be using slides from the Henneman book, but I wasn't able to get them incorporated into this course at this time. So what I'm going to speak about mostly here until I get to the summary from Henneman is affirmative action as it applies to federal contractors. Affirmative action, as we know it today, is actually implemented, set into action by Executive Order 11246, signed by President Lyndon Johnson in 1965. Affirmative action is under fire today from many sides, and the U.S. Supreme Court has been chipping away at the tenets of affirmative action for at least the last 10 years. I expect that to continue. Interestingly enough, when I mentioned in the first week the two cases at the University of Michigan, which Bollinger was the defendant. Bollinger was the president of the University of Michigan at that time, and now he's the president at Columbia University in New York. Were both decided by 5-4 margins, and the justice who wrote the majority opinion in both cases, Justice Sandra Day O'Connor, cited clear differences here, but she also said, and I don't remember, was it actually after that case or sometime later in a conversation, she said that by 2025, roughly 10, a little over 10 years from now, we would no longer need affirmative action in the United States. And that's a possibility. One of the problems that people have with affirmative action is that it is not codified in law. In other words, it has not been enacted by the United States Congress and signed into law by the president. However, executive orders do have the force of law. And this is where people have a lot of problems. They don't understand that that's the force of law, and yet it's not been enacted by Congress. Many presidents have used executive orders to do things that fall within their jurisdiction. And we have a problem with this because when we see presidents signing executive orders, we get the idea that he is acting, and I'm saying he, hopefully some year we'll have a she, acting as a royalty, as a member of the royalty, when in fact there are a number of things set forth in the Constitution that the executive, the president, has the authority to act upon on his own recognizance. Now, hopefully they would not be unconstitutional. And that's where people have been chipping away at the affirmative action based on the Constitution. So people sometimes don't see that our original Constitution and the first 10 amendments, called the Bill of Rights, really didn't do a lot of protection for minorities. In other words, we'll say, well, we have the 13th, 14th, and 15th Amendments, which I'm going to talk about a little bit later tonight, so we don't need all the rest of this stuff. Well, I wish that were true. The fact of the matter, it isn't, so we do have these things. The AA program that most of you saw and responded to in the text can be voluntary. And as I mentioned, you picked up on the guidelines that the court has set forth after its decision in Weber versus Kaiser Aluminum. And I'm going to address those in some case. Some guidelines will be addressed. Protection for minority classes especially are important, and that program must be temporary in nature. There's no question about that. You can't trammel on the rights of the minorities simply to do something for the majority. I mean, for the minority. Part of the problem that we have is a misunderstanding of what affirmative action is going to be. And I talked about this in week one. I really don't want to revisit that too much, other than to say a lot of us have this idea in our minds that affirmative action requires quotas. And the fact of the matter is it does not. What affirmative action does say for those that have federal contracts is their workforce ought to mirror the population of the local area. And that simply makes sense. But it also says, and I'm going to talk about this a little bit later, that no employer is required to hire an unqualified person. It doesn't say that. It never said that. And so, we have to lose that baggage. Now, I know that you may be sitting here either tonight listening to me or late this afternoon, or may watch the recorded lecture tomorrow and say that I'm passionate about this. Yes, I am. Affirmative action has never done anything for me. I'm a minority. I'm not the minority. I'm a majority, and I'm a male. So why do I think this has to be done? Because we talk about equality in this country, and we talk about giving people equal opportunity, and that's what this is about. So while many programs are voluntary, I'm going to speak about the pardon me about the mandatory programs. And that's what Supreme, our case study, it falls under. It's a federal contractor, or it's become a federal contractor, just winning a contract for something over $1 million. And there are 3 levels of mandatory programs under AA for federal contractors. The first is contracts that exceed $10,000 but less than $50,000. These organizations fall under what is known as the Equal Opportunity Clause, government contracts. Equal Opportunity Clause - government contracts. Major points of that clause are: the contractor will not discriminate against any employee based on race, color, creed, etc. Notice that's one of the major things. Will not discriminate against an employee, a current employee. The employer will take affirmative action to ensure applicants are employed and that they are treated during employment without regard to race, color, creed, national origin, etc. This includes, but is not limited to, promotions, demotions, training, layoffs, etc. So let's look at the layoffs. So the layoffs simply mean if your policy says the last in is the first laid off, you have to continue with that policy. And you can't jump over someone simply because of his or her color or race or creed or whatever those prohibitions are. I'm not going to do that line because we all kind of know what they are. So you must be consistent. The contractor will state in advertisements for employment that all, listen to this next word, all qualified applicants will receive consideration for employment regardless of race, color, creed, national origin, etc. The contractor will advise each union or workers' representative of the contractor's commitment under Section 202 of Executive Order 11-246 and post the notice in a conspicuous place. Now, I didn't go into that Section 202. That's not really important for our discussion tonight. The contractor will furnish all information required by Executive Order 11-246 for the purposes of investigation to assure compliance. If the contractor is found in violation of the non-discrimination clauses or rules, regulations, and/or orders, the contract may be canceled, terminated, or suspended in whole or part, and the contractor may be declared ineligible for further government contracts. The contractor must include the provisions of paragraphs 1 through 7 of Section 204. Again, we're not going to go into that, of Executive Order 11-246 to ensure they are binding on any subcontractor. The third level of control of contracts under 11-246 is when contracts exceed $1 million. Here's where Supreme comes in. In this case, the contractor must meet the requirements the specifications of the Equal Opportunity Clause and the Office of Federal Contract Compliance Programs. That's normally referred to as OFCCP. It is authorized, that office is authorized to conduct a pre-award compliance review. Now, since Supreme is a new federal contractor, all factors may not be considered because they're new. And a lot of times what happens is, or what should happen, is a company like Supreme ought to ask for assistance from the federal government in writing the plan. The most important factors are past equal opportunity performance, including the current equal employment opportunity profile and any indication of underutilization. Now, if we look at the case, it's a little hard to read into cases, but it seems that Supreme is a relatively small company, or at least a mid-sized company. And it does have, I believe, as I remember, I should probably pull this out. I should have pulled it out tonight. Does have some minority employees. So what they're looking for here is past discrimination. The number and nature of complaints filed by current or past employees, if there are any, they should be on file with the Equal Employment Opportunity Commission. Whether the contractor is in a growth industry, I don't think that's necessarily germane in this case, but it could be. The level of employment and promotion opportunities resulting from expansion or turnover of the contractor's workforce. And then employment opportunities that are likely to result or be the results of being awarded the contract. So we know that Supreme is, I'm going to use the term mid-sized company. They may not even be a mid-sized company. It may be a small company, depending upon our definition of size. But what we have to talk about here is that Supreme is going to grow. And because Supreme is going to grow, there are going to be employment opportunities. Now, we need to go back to the original statement here, not the original statement, one of the original statements, and that is Supreme is not required to hire anybody who is not qualified. It's as simple as that. And the thought process is that them not doing so, or them doing so, really have to do away with that. Jesse Helms was the United States Senator from North Carolina for several terms. And in one of his re-election campaigns, he showed a picture of a fellow trying to find a job. And it says you were the most qualified, but you didn't get the job because of a quota. That was patently false. And yet it continued to run, and Helms was reelected. We need to get rid of this thought process that equal opportunity and or affirmative action is doing something for minorities and women that it isn't doing. You know, if we really put these things to work and said, okay, it's going to be quotas, the minority community in the United States wouldn't have double-digit unemployment rate, which it does. The Office of Contract Compliance Programs, OFCCP, is very clear about what must be in a contractor's affirmative action plan. It must include the CEO's attitude statement regarding equal employment opportunity. Who is responsible for designing and implementing the plan, affirmative action plan? Who will monitor the program and the applicable reporting procedures? The plan must state how it intends to recruit, hire, train, and promote without regard to race, color, creed, national origin, etc. If in fact they're going to have a bona fide occupational qualification, which I'll talk again a little bit about tonight, that must be mentioned. All employee benefits will be administered without regard to race, color, or creed, etc. Finally, the primary focus of an affirmative action plan is on goals and timetables to achieve them. How are we going to try to attract additional minorities and women to our workforce? And what's our timetable to try to achieve that? Now, doesn't mean to say that that timetable is set in stone. What it means to say, this is our goal, this is how we're going to do it. And one of the things that companies have to be careful about when they write affirmative action plan, this careful for themselves, is not to put themselves in a position of saying we're going to have X number of minorities and X number of women 2 years from now, when you don't know that. That's a goal. And this is what we're doing to try to reach that goal. Goals should be specific and attainable. So if you can't attain something in 3 years, 2 years, whatever it happens to be, don't make that statement. Specific, we want to have this percentage of women and minorities employed on our workforce. And then the timetables have to be reasonable. I like to use the case of Xerox, and I may have talked about this in week one. I'm not too sure. Xerox went on a minority recruiting campaign in the 1960s, the late 1960s, as an initiative to answer the race riots that rocked cities in the country. And what they found is that they were very successful in hiring minorities, but then they found out that just as many minorities as they hired went out the back door because they weren't getting these equal opportunities and promotion, etc., that we talked about here. And so Xerox set out to do that, to make sure that they had an inclusive workforce, and that they set up mentors for minorities and women. And today, 50%, roughly 50%, might be 49, but it's right about 50% of their workforce are made up of women and minorities, and an equal number of those women and minorities are in senior executive positions. So, well, let me back away from senior executive and use the term upper management positions. That's a little bit better. And of course, as you know or should know, the current CEO of Xerox is a woman by the name of Ursula Burns. She is not only a woman, she's a minority, and she succeeded another woman CEO. Now, Ann Mulcahy was not a minority, but she was a woman. First time in American history, first time in American business history, Fortune 500 company, a woman's CEO succeeded another woman's CEO. And of course, the benefit was that it was also a minority in Ursula Burns' case. So let me wrap up here a little bit with what Henneman says. Some of what Henneman says is pretty much said in the case that the court rendered in Weber versus Kaiser Aluminum. But what they also mention that is not mentioned here is that all candidates, this is again the voluntary program, all candidates for positions should be qualified, which we've said before, which is in the affirmative action guidelines themselves. The plan should include organizational enforcement mechanisms as well as a grievance procedure. Now, we can expect that there may be stricter guidelines because this court is not amenable to affirmative action. And so we're liable to see them becoming stricter and stricter. And racial preferences are subject to strict constitutional scrutiny. And I would agree with you. I would agree with that interpretation. because that's where we get ourselves into trouble. However, your workforce ought to mirror the population segmentation, diversity of the area in which you operate. It just makes sense. This makes sense. Well, enough about affirmative action. I could probably go on about affirmative action for another 20 or 30 or 40 minutes. But we need to talk tonight about how we got where we are with equal employment opportunity and things of that nature. Why is it that all of a sudden we saw things change in the 1960s? So what we're going to talk about a little bit tonight, after I talk about some other things here, is a little bit of a history lesson. I'm not a historian. I don't have a degree in history. I've always been interested in history, and I try to follow it as much as possible, especially history of the United States. And I encourage each and every one of you to learn that, because that's how we learn how we got to where we are today. So yeah, a lot of tonight we're going to talk about Griggs, and Griggs is very important. But we're going to spend some time on talking about pieces of important legislation that have affected workers in the United States on the job and in employment, etc. Now, the first one I want to talk about is the National Labor Relations Act, also known as the Wagner Act, named after Senator Robert Wagner of New York. This act protected the rights of employees to form and join a union or refuse to join a union, or just decide, let's not use the word refuse, that's a strong word, to say I don't want to join. The Norris-LaGuardia Act, 3 years earlier, LaGuardia, you may recognize, there's an airport in New York named LaGuardia. Fiorello LaGuardia was a congressman from New York, and he was also mayor of New York for a couple of terms. This was passed in 1932, and it stopped an extremely terrible, that's my word, that's my term, business practice. The act outlawed what was known as yellow dog contracts. Employers forced these contracts on employees, and the contracts forbade the employee to join a union under pain of termination, or even to do any type of union activity, such as organizing, etc. The act also prohibited courts from issuing injunctions against nonviolent strikes. Now, this is not a human resource management course, but we need to understand that the Taft-Hartley law in 1947 made some changes, and the president can order a cooling off period. Courts can also issue injunctions, but for the most part, in other words, injunctions would make workers go back to work. A cooling off period would do the same thing. Most of the time, we don't see these in strikes other than where national security is being compromised in some way. There was an injunction in the steel workers strike back in the late 1950s. There was an injunction against the coal miners strike back in the 40s, and I think another one in the 50s, things of that nature. Now, you may recall, I'm not sure, you may not, in the early 1980s, pardon me, the air traffic controllers had a union, and they walked out on strike. And the president at that time, Reagan, issued sort of a warning, and said, if you don't come back to work in, I've forgotten how many days he said, you're going to be terminated. And I think the strikers did not think that was going to happen. They called the president on that, and he effectively did terminate them all. Now, whether some of them went back to work, pardon me, as non-union members, I don't know. But we have to think about that. We have to think again here about people in unions and their rights. I'm not here to discuss whether or not we need to have unions or not, and whether or not unions are corrupt, etc. If we're going to argue that, we can also argue that businesses are corrupt. We know some of them are. Some people have gone to jail for corrupt practices. What we need to think about here, though, is collective bargaining, which we have agreed to allow in the United States, and that people need to be treated fairly as is required by the Constitution. Now, by the same token, we don't expect strikers to go out and break the law. And when they do that, they need to be held accountable. So those are things that we need to think about. Old Age Survivors and Disability Insurance Act of 1935, better known as Social Security. Notice the term here that I used, not that I used, that comes from what this act is: Old Age Survivors and Disability Insurance. Social Security was never meant to be a retirement. And of course, Social Security was implemented when people did not live as long as they do today. And we have some other issues with Social Security, but we need to remember that it was never meant to be a retirement system. And secondly, we need to remember that every time Congress starts complaining about it, Congress needs to remember that they have never refused to increase the cost of living that goes along with Social Security. Now, some of our more recent Congresses have taken a harder look at Social Security, and that's fine. But we have to remember the original intent was not as we see it today. Fair Labor Standards Act, of 1938, set minimum wage except for farm and retail workers. And it also outlawed child labor. Or we maybe not so much use the term outlawed, it codified what child labor was, where children under age 18 could work, the hours that they could work, the type of industries that they could work in or could not work in, the number of hours they could work, etc. So there's other recent legislation. We talked about some of this before, but I really don't want to get into the ADA, the FMLA, the Pregnancy Act, the Age Discrimination Act, etc., or even the Civil Rights Act of 1964, or the Civil Rights Act of 1991, both important pieces of legislation. I'll talk a little bit about that in a minute, but I want to set the tone for where we got today, or how we got here today. And we need to look at some of the older legislation, some of the older legislation that we have on the books, and kind of in a way ask ourselves why we needed the legislation in 1964. I want you to think about the three amendments of the Constitution that I'm going to mention to you. And we need to ask, when these are mentioned, or you need to ask in your minds, why didn't they do what they were supposed to do? The first was the 13th Amendment to the Constitution, which was enacted by the Congress. Well, let me change that, because there's a different procedure for constitutional amendments. It was passed by the Congress on January 31st, 1865. If some of you saw the movie Lincoln, which was out in the last couple of years, that it was a good part of that talked about the 13th Amendment. It was ratified by the states almost a year later on December the 6th, 1865, and became part of the Constitution. The 14th Amendment, which was passed by the Congress on June the 13th of 1866, and then ratified by the states on the 9th of July 1868, guaranteed equal protection for all citizens under the law. Then we had the 15th Amendment, which was passed by the Congress on the 26th of February, 1869, and very quickly ratified by the states and became part of the Constitution on the 3rd of February, 1870, just a little over, not quite a year later. And it bestowed the right to vote on black males. And then finally, not in chronological order, we had the Civil Rights Act of 1866. All citizens, according to this act, all citizens have the same rights as white people. That is, own property, enter into and enforce contracts, etc. That's a very, very powerful statement. So these amendments to the Constitution and the Civil Rights Act of 1866 are very, 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 very strong, as I've mentioned. So why do we need later legislation? Why did we have to wait almost a century from the Civil Rights Act of 1866 to the Civil Rights Act of 1964, and specifically Title VII of that? Why did we have that? I mean, it seems to me, and it should seem to you, that we had things in place. Why did we need a fix? It shouldn't have been broken. But it took a century for us to get back on track. And how did that happen? Very peculiar. Part of the answer, at least to me, stems from the election of 1876. The presidential election held that year had no clear winner and was thrown into the House of Representatives to vote. Now, that's only happened a couple of times in our constitutional history. The first was between Thomas Jefferson in 1801 and Aaron Burr also in 1801. Now, they were tied, and the president at that time was John Adams, but they were tied, and it's I remember it took 73 ballots in the House of Representatives. I remember reading, I wasn't around at that time. That's 73 ballots by the House of Representatives to choose Jefferson as the president. They were both tied in the number of electoral votes because in those days, people didn't run as a ticket. So you had a president and a vice president running on the one ticket. So in and then of course again in 1824, when Andrew Jackson won the popular vote, but John Adams had more electoral votes. Then they went to maybe Jackson had more electoral votes, but didn't have a plurality. As a matter of fact, I don't think Jackson did. I think Adams did. But anyway, they went back and forth, and eventually Henry Clay threw his votes in with Adams, and Adams was elected president. Well, anyway, what we had in 1876 was that Sam Tilden, the Democrat, who was at that time governor of New York, won the popular vote, but he did not have a majority in the Electoral College, and therefore he could not become president. I don't remember what that number was, 180 something. That sticks in my mind. So, and on top of that, some of the Electoral College votes that Tilden did win were in dispute. So Congress established a commission to resolve the dispute and eventually elect the president. In the end, some Southern Democrats stated they would support Rutherford B. Hayes, the Republican, if he agreed to provide funding for Southern improvements and end Reconstruction, which the Southern states looked upon as being occupied. So what happened here is that Hayes agreed, or Hayes' agents agreed, and he became president, and the South won what is known as, or what I call, Home Rule, also known as White Rule. This allowed the South to overturn laws that had helped blacks improve their condition. We then saw the advent of Jim Crow laws, which brought about segregation in all of its horrible forms, worse than what we had had before. Separate but equal was one, and actually what we should say was separate but unequal. This policy was eventually given strong standing by the United States Supreme Court in its terrible decision in Plessy versus Ferguson. This is very interesting because Plessy was a black man. He lived in New Orleans, and New Orleans at that time was a very, very, very progressive city. Whites and blacks mingled, and there were others down there, other minorities as well, and there doesn't seem to be any real problem with that. Well, of course, the South had the separate but equal, and that extended to railroad cars. And what that meant is that there was a car on the train, or more than one car on the train, that blacks had to sit in, and they couldn't mingle with whites. Well, Plessy, as I read before, was a very light-skinned black man, and some of his friends put him up to sitting in a railroad car with white people. And so Plessy sat there, and in fact, what really happened was some of Plessy's friends had to go tell the conductor, you have to come up here and arrest Plessy because he's a black man. So he did, and Plessy went to jail, and he was convicted, and then Plessy had his case eventually heard by the Supreme Court, and the Supreme Court mandated that separate but equal was okay. And eventually, it essentially became the law of the land and was not overturned until Brown versus the Board of Education, a Kansas school case, in 1954. By the way, during that time, conditions for blacks in the North were not a lot better, but they didn't have those kinds of laws. So how was it in the 1960s, or the 1960s became a ripe time to undo all the bad things that had begun in the 1870s? Well, of course, they had their genesis before the 1870s, but now, once the federal government took its hands off and didn't care what the South did, the South was just back getting revenge. A guiding principle in Western society has been that people should be rewarded based upon merit. That is, on the value of their contributions. That principle is part of the American dream, and we can see this in our two most important founding documents, the Declaration of Independence and the preamble to the Constitution of the United States of America. Until the 1960s, however, the dream and principle was not extended to people of color, and in many cases not to women either. And women didn't get the vote until the 1920s. So the 1960s saw the following: a change in societal values within the United States, the economic status of women and minorities, specifically black, was considered, and there was some concern about that, and then intervention by the federal government through laws and regulations. In addition, American businesses supported the concept of equal employment opportunity. Don't confuse that with EEOC. EEOC is the Equal Employment Opportunity Commission. EEO is Equal Employment Opportunity, and for a long time, you may still see it today. I haven't looked at an advertisement for a job in a period of time, but for a long time, companies would put that in their advertising statements. EEO. In addition, in the 1960s, we witnessed demonstrations led by Dr. King and by his cohorts and others that turned violent when authorities intervened. Peaceful marchers had dogs sicked on them. They were hosed by powerful water cannons and from fire hoses. American public really was taken aback by that, and they were turned off by the tactics used by Southern police forces. and those tactics became a clarion call to change the law and level the employment playing field. The 1964 Civil Rights Act, especially Title VII, was the starting point that led to the following laws governing certain aspects of employment. Age Discrimination Act of 1967, Pregnancy Discrimination Act of 1978, Americans with Disabilities Act of 1990, and then the Civil Rights Act as amended in 1991. We discussed most of that legislation in week one, and I'm not going to dwell on it again tonight. But it's important for you to understand how we got here, where we are, and why we have enacted these laws. It's also important, and I want to close here this first hour with, and I may have done this in the past, and if I did, I beg your indulgence. It's also important to understand how President Johnson came to sign the Executive Order 11246, which implemented affirmative action. President Johnson was from what is commonly referred to as hardscrabble area of Texas. Things don't grow well there. There's a lot of desert, a lot of dry area, etc. And after he graduated from college, he was in a very small college, a state teachers college, I believe. He came back and taught school for a while and saw firsthand how many of the Mexicans that he knew and other Hispanics, but mostly Mexicans, really had no chance to move out of the poverty that they were in simply because they couldn't get jobs. And so his idea was if we level the playing field, but this was on top of the Civil Rights Act, which he was very instrumental in getting through Congress after he became president due to the tragedy with President Kennedy, that he felt that he could go even a step further and mandate this affirmative action for employment of people by federal contractors. So he did this based upon experience, not personal experience for himself, but personal experience witnessing the privation that many folks went through. He felt it was very necessary to do those things and to make those changes. And we know that affirmative action, as I mentioned earlier in this hour, is under fire. It's probably going to continue to be under fire for some period of time. And of course, I would tell you that affirmative action should never trample on the rights of the majority, and it should never be seen as preventing someone from being able to do the things that he or she thinks that they're legally entitled to do. However, there are protections that we have to think about. We have less advantage in this country. We have more or less advantage in this country than we should. And we ought to give them an equal opportunity to earn a reasonable living. And I want you to pay attention to the word I used, equal opportunity. I didn't say give a job. I just said equal opportunity. And I think that's incumbent upon all of us to do that. Yes, this may sound like a little preaching, and if it does, I apologize for that. I don't intend to offend anybody. I do want you to open your eyes and cast your horizons wider to see that there are people who need opportunities and have been denied opportunities simply because of their race, color, creed, or national origin. That's not what we're about in the United States, and we need to think about that. So anyway, we're finished. We're 5:19. Have spent the last almost 50 minutes discussing affirmative action and some of the laws that got us to where we are today. So I'd like to take a break now till 5:20. Excuse me, to 5:25, and we'll come back and discuss Griggs, mostly Griggs versus Duke Power, and perhaps talk about a few other things, and then spend a little bit of time talking about disparate treatment and disparate impact. Thank you. Please come back at 5:25. All right, we're back, and we're going to discuss some issues about, we discussed the very famous Briggs versus Duke Power case back in the 1970s. And your assignment, written assignment for this week, and there are a couple of, at least one court case that I remember, Torres versus Pisano, and I'll talk a little bit about that tonight. Not the case itself, but sexual harassment, which that case is about, is to select a piece of federal law that is legislation enacted by the Congress. Now, I want to repeat federal law. I had a student some time ago who talked about a piece of federal legislation that was never enacted by Congress. That doesn't count. It has to be federal law. legislation, or a federal court case, preferably a Supreme Court case, one decided by the Supreme Court, that is aimed at or affects recruiting, selection, and staffing of employees. Your assignment has to cite the law, the piece of legislation, or the court case and evaluate its impact on recruitment, selection, and or staffing. And then I have some information there about the Griggs case, which we're going to discuss at length tonight. And then we're going to look at some slides we have here about this. Federal court decisions, federal court decisions that address employee recruiting, selection, and staffing, especially those rendered by the United States Supreme Court, have significantly affected employment practices. Supreme Court decisions are final. Now, I want to step back from that a second and say this. Supreme Court decisions are final if they are not changed by the Congress. Now, what I mean by that is the Congress doesn't actually change the Supreme Court's decision, but it revisits what the Supreme Court did and then crafts legislation to address the areas that the Supreme Court said were deficient in the original law. This is not to say the court doesn't reverse itself, as we talked about before. It reversed itself when in the Brown versus the Board of Education case in 1954, when it essentially overturned the Plessy decision of 1896 without actually saying that. We talked about it before, separate but equal, and in 54, a unanimous Supreme Court said separate but equal is unconstitutional. Now, interestingly enough, the court had done that before. There was a case brought before the court in the late 1940s. I want to say 1947, but I'm not sure that's correct, so please don't hold me to that date, where a black gentleman who was a law school student in Texas sued the state of Texas because he was not able to go to the University of Texas at Austin for law school, but was admitted to law school, and his school was like over top of a restaurant or someplace else. So he was saying that he was in unequal conditions. He didn't have access to law books and law library and things of that nature. And the court did agree with him. I don't remember exactly how Texas handled that, but that case did come before Brown versus the Board of Education. Of course, it didn't have the resonance that Brown versus the Board of Education did. The cases that you'll find in your text, there's approximately 24 of them in Chapter 3, continue to be the law of the land. So it's important to examine them and review their significance regarding employment practices. Now let's look at some slides here. It's important for HR practitioners to understand the law so they're complying with it, because that saves the organization resources. Now, the slide says money, but it saves other resources, because if you have to argue your case before a court, it's going to cost you time and effort to put things together, to build your case, perhaps hire attorneys, which is going to cost you money, or you have employees doing things for this case to build up your side of the case, to provide documents, etc., when they could be doing other things. So it's better to stay abreast of the law, whatever the laws are, as opposed to not doing the things that you need to do. And here's the major employment laws. We talked about some of them before. The two Civil Rights Act, Age Discrimination, Equal Pay Act. which really don't hear a lot about today. It was passed in 1963, and then the Family and Medical Leave Act, and then Executive Order 11246, which we spent most of the last hour talking about. This talks about what Title VII did, the Civil Rights Act of 1964, and racial discrimination in employment practices. And pretty much has done a fairly decent job, I think, over the period of years. This is what Title VII does: provides protection to all people. All people, doesn't say certain people, all people, based on those discriminating criteria: race, color, national origin, religion, sex, gender, etc. And people who fall into these categories are referred to as protected classes. However, it's important to remember, provides protection to all people, not just to some. It is true, and I think we can say that some people, some classes of people have benefited more from this law than others have. But that's to be expected, because that happens many, many times in laws, with laws. Law originally covered companies with, this is Title VII of 1964 Civil Rights Act, companies with 25 or more employees, been amended to exclude companies with fewer than 15 employees. And then, of course, we talk about the bona fide occupational qualifications, and then religious organizations are exempted because they will normally have these bona fide occupational qualifications, which many times talk about their people who work for them have to belong to certain religions or not. So here's discrimination. Notice again, this is when all people are not given the same opportunity. And equal employment means people should be given an equal chance at any employment opportunity within the organization, regardless of race, creed, gender, etc. And that extends to, as we've said before, not only employment, but promotion, training, benefits, even extends to layoff. We don't want to have to go there. Now, Title VII offers protection here, as you notice here at the bottom of the slide, in 3 separate areas: disparate treatment, adverse impact, also known as disparate impact, and harassment. Now, disparate treatment is the one that's very easy to understand. We don't have to search our brain for disparate treatment because it already tells us that we're discriminating. We're treating a class of people differently than we treat another class of people. And it's already told us we're discriminating against a class of people because we treat them differently. And the only place that you could say where disparate treatment would be allowed is this next thing, and that's where we talk about a bona fide occupational qualification. And the example that I used about bona fide occupational qualification was, I think 2 weeks ago, is where a woman who wanted to be a guard in a state prison in Illinois that housed male prisoners. And the state of Illinois successfully argued that they had a bona fide occupational qualification, that they had to have male guards guarding male prisoners. But you're not going to get, well, I have a case of what could never have been bona fide occupational qualification to talk about a little bit later in our session here tonight. So normally we find this is a very restricted area. The courts have interpreted bona fide occupational qualification very narrowly. So it is not broad. You're not going to see it. women years ago, I mean specifically using women years ago, they were precluded from certain jobs because they couldn't lift a certain amount of weight. And sometimes you found that in firefighter positions, sometimes you found it in police officer positions. I'm only using those two as notional because they did happen. Well, because some women couldn't lift a certain amount of weight doesn't mean that all women couldn't lift a certain amount of weight. So that could never be used as a bona fide occupational qualification. Well, it was used for years, but it was before we came up with this term about bona fide occupational qualification. So courts have been very narrow in their interpretation of this. I think that's for the better. We do see cases where religions usually can be successful at that because they'll talk about they have to have people that belong to their religion working for them, et cetera, et cetera. Now, all religions don't follow that. So I don't want to pick on, and I'm not going to pick on any particular religion, but I know some have been successful at saying we need to have our people, only our people working for us for various and sundry reasons, and they have to spell that out. And as long as they can make a legitimate case for it, the courts are probably going to let them have it. Now, notice that if they do use bona fide qualification, occupational qualification, and it is a legal use of a bona fide occupational qualification, then it can be an exemption from disparate treatment. Remember, disparate treatment, we already said we're treating one class of people differently than we treat this other class of people. We've already told you we're discriminating. Now, religious organizations do seem to be able to meet the bar that the courts have set for this. They're okay. They've met that standard. They're not actually doing that. Actually doing this discrimination as we would think it would. All right. So we are going to get to adverse impact next, but we need to talk about Willie Griggs. Willie Griggs is a black man from rural North Carolina, and he sued, or the people who were helping Griggs out sued on his behalf against Duke Power. And the case went to the United States Supreme Court, and the court decided the case in 1971, and it did side with Griggs, and it had some far-reaching statements about Griggs that we need to talk about, and we will talk about shortly. It is a significant case because it touched not only on the central issues of the case, disparate impact, or adverse impact, as you prefer, but on other employment facets or other facets of employment as well. Duke had a employment rule, one of its employment rules, that stated to be hired, you have to have a high school degree or a general equivalency diploma. And then that was coupled with receiving a satisfactory score on 2 aptitude tests. Griggs, as I mentioned, black man from rural North Carolina, and he argued, or his attorneys argued for him, that most blacks in his area were not afforded the opportunity to earn a high school degree. And having one should not be a criteria for employment as a coal handler. And if you remember, we have a case here that we discussed, you've discussed, and I responded to a couple of you. I'll finish that up tomorrow, about a meter reader having to have a college education. What does having a high school degree have to do with telling someone or telling some company that a person could be successful handling coal? That's moving coal from one place to another. What is it that having a college degree tells an employer this person will be a successful meter reader when the only thing you have to do is drive up to the either a person's home or to a business establishment and read either the gas or electric meter. Now, if that requirement said that person has to have good visual acuity, and maybe that he has to have a rudimentary understanding of mathematics to be able to read and say, okay, this is 75 as opposed to 85 or something else. He knows the difference, or she knows the difference in numbers. Yeah, I could buy that, and I'm sure you could buy that. But a college degree, and on top of that, to work for $8 an hour, which is not a heck of a lot more than minimum wage, and to compound that with the fact that this is in a depressed area of Cairo, Illinois, that has a very high unemployment rate, doesn't have a lot of citizens living there, and I submit to you that the vast majority of those people who do live there don't have a college degree. And that surrounding area. Now, yeah, you're going to find probably the local pharmacist and the lawyer and the dentist and the town doctor. Yeah, they're all going to have degrees, but the vast maybe the banker, but most everybody else isn't going to have one. So imposing things on people, it doesn't make sense. And this is where this disparate treatment, especially in that, and I don't think I even used that in responding today. This is where this disparate treatment would come in, because, well, yeah, I suppose adverse impact, because saying I have a college degree is going to adversely impact upon people from minority classes, because they're not going to have the opportunity to have it. So, when you're in that kind of an area, what is the opportunity for most people? And college degree isn't going to be one of them. Furthermore, Griggs argued that there was no defined relationship between test scores and or the tests themselves, let alone the test score, successfully passing the test, and the ability to perform on the job. So let's look at adverse impact. Adverse impact is when a company's policies, employment policies, now we want to talk about here because we want to make sure we define this correctly. When the the company's employment policies treat everybody the same. In other words, in the Griggs case, everybody had to have either a high school degree or GED equivalency diploma, general equivalency diploma. I think that's what it stands for. And then they had to take 2 aptitude tests, and of course successfully passed them. So that's neutral. Everybody's got to do that. But here's the crux of this. It's going to result in different employment opportunities for some people. Everybody in Griggs was a minority, most likely in North Carolina at that time, probably didn't have a high school degree unless they were from big city like Charlotte or Raleigh, or maybe one of the other ones, Winston-Salem perhaps. But if you were from rural North Carolina, no. And that probably even extended to whites in rural North Carolina as well. But certainly blacks would fall into that. Now, here is the next point you have to look at here. Companies do not violate the law if they hire fewer minorities. I'm skipping the word protected class. If they use the appropriate methods, testing, etc., in their hiring decisions. So what they have to do here is, and I'm jumping ahead of Griggs because this doesn't even apply to Griggs. But what they have to do then is show that their tests are valid. Now, there's 2 measurements to a test, and that you have to do in any kind of testing for employment. You have to show that the test is 1, reliable, and 2, that it's valid. Now, reliable simply means that the test will show consistent results from different people taking it time after time after time after time after time. Validity means that the test is designed to measure and does measure what it claims it's going to measure. So let's go back to Griggs. How could an aptitude test measure a person's ability to pick up coal from point X and take it to point Y? I'm sure in some respects you could design a test to do that. But then you wouldn't be measuring what you wanted to measure. So, you know, this was the crux of Griggs. You can't be doing something simply to be doing it. Simply to say, well, we're neutral here. But by the way, everybody has to take this aptitude test. So, as we say here, Griggs centers on disparate impact or adverse impact, as these authors use. It's also known as unintentional discrimination. We didn't mean to do it. If we knew better, we may not have done it. That's my term. It's a consistent thing that probably would never have gone to court if Griggs hadn't lost his case. I mean, if Griggs hadn't taken his case to court, said, wait a minute, you know, I'm being discriminated against. So this is what happens when, and I'm going to add to this here just a little bit from what you see on the slide. And this is when an employer has racially neutral employment practices that, as we say, are disproportionately exclude protected class. Griggs claimed these employment requirements were unfairly discriminatory in that they rendered a disproportionate number of blacks as not being qualified for employment. Just saying this a little bit different, perhaps a little bit stronger. Now, let's take it before we get to what the court said, because the court obviously, as you know, did uphold Griggs' claim. And as we also know, the court went a little bit further than just talking about unfair employment practices. It laid down some parameters. So adverse impact cases proceeds the plaintiff demonstrates unequal hiring practices, known as the 4/5 rule, 80% rule. And we don't need to get into this, but what it shows here is a greater proportion, if you prefer, of job applicants is being hired in the majority group than in the minority group. Most likely in Griggs' case, and I've not looked completely, and I've read the case, but I probably missed part of it. Most likely in Griggs' case, there were darn few blacks that were being employed by Duke Power. Now the company comes back and says, well, wait a minute, that's not right. We can validly show that our testing is not discriminatory. It actually identify people who are likely to succeed on the job. Actually, most people will tell you the test will accurately predict who will not be successful on the job, as opposed to predicting who will be successful on the job. And I say that because there's varying degrees of success. There's no varying degrees of non-success. Non-success is non-success. Period. Step down, next case. So what they're saying here, what Duke would be saying, if it could say that, or try to say that, is that the process that we use corresponds to performance, or it predicts performance, or it predicts non-performance. Now, if it predicts performance, that's fine. If it predicts non-performance, that's also fine. What it's saying is this test is job-related, and it's valid because it measures what it's supposed to measure. And then the plaintiff can come back and say, well, now wait a minute, there's other ways to do this. and it doesn't hold water. Now, the problem we have, a little issue, not a problem, issue we have with Griggs is we're not talking about tests that were made to measure job performance. It measures his aptitude. And I submit to you, and I don't mean this, and please don't anybody shoot me. You could probably train an animal to do that coal handling. That might take you a little bit of time, and it would be a little bit different, and it may not be as much as a human could do, but you could probably do that. So what is an aptitude? How does an aptitude test measure ability to, because there's no cognitive ability here we have to worry about. We just have to worry about taking coal from one place to another. Somebody can be trained to do that. You don't need cognitive ability. This is validity. We talked about that. Now, again, we're talking about the 4/5 rule, etc. We don't need to speak a lot about that. Select employees provide assessments that accurately identify people most likely to succeed. It goes a little bit more to the 4/5 rule, and I'm not going to go through that because this has been changed by the Civil Rights Act of 1991, so we don't need to, it's been changed somewhat. So final burden of proof is on the company. They have to show the validity of their selection process if they're going to rely on tests. And that's a criteria we have to pay attention to. All right, let's take this off for a minute. We'll come back and talk about sexual harassment in a minute. While the court agreed that Duke did not and could not demonstrate the tests were job related, if that were the only decision it rendered, it may have had little impact on hiring practices. They probably would have done away with their tests, but it wouldn't have changed a whole lot. So they just eliminate unnecessary hiring practices, requirements that were not job related to high school degree, aptitude tests for jobs that didn't require higher level thinking or cognitive thinking. The court, however, as it often does, went further, and it made the following specific comments, writing that, one, and by the way, you can see these in the text. I've amended them a little bit to sound, not to sound better, but to take some things and stress some things and leave some others out. Employment practices that may seem neutral but adversely affect protected classes' abilities to gain employment are illegal. So it simply said, not only did it say, we talked about it before, they probably would have stopped those. The court said you can't use them. If organizations use tests in a hiring practice, and we know that you do, there's typing tests and all kinds of tests, they must be job related. That is, the tests must be able to measure how well a prospective employee will perform on the job. And as I said, if it shows that the employee cannot perform on the job, that's acceptable as well. As a matter of fact, you'd probably rather have a test that will definitely tell you employee X cannot perform this job, as opposed to marginalization of these other people who performed at least minimally satisfactorily, because most likely you could train those people up to speed. The person that is not going to perform satisfactorily, it would probably cost you too much money to train that person up to speed, and therefore that's a good discriminator. Organizations must demonstrate, prove, if you will, that the tests are job related. In other words, they have to show that. And that's where Duke failed in this case. We could probably make a case for the high school diploma. I don't think we could, but we might be able to. We couldn't make any case for those aptitude tests, none whatsoever. It wasn't just one; it was two. Companies must show the tests are valid. We talked about that. To be valid, a method or a test. And by the way, courts have ruled that performance appraisals are tests, job interviews are tests. For selecting employees must accurately predict the potential employee who will perform well on the job. The test must show that John Smith can perform the task and will be successful, while John Jones cannot perform the tasks and will therefore be unsuccessful on the job. In addition, with this ruling, the court expanded the definition of illegal discrimination to include what we now know Griggs actually argued, and that is that Duke was guilty of disparate treatment or adverse impact or disparate impact. The concept of disparate impact discrimination was further clarified by a subsequent Supreme Court case and was codified by the U.S. Congress in the 1991 Civil Rights Act, Title VII amended, by the Civil Rights Act of 1991, which amended Title VII of the 1964 Civil Rights Act. It says that a disparate impact claim is established if the following conditions are met, which is a little bit different than what we saw in the slide before. A plaintiff demonstrates that a defendant uses a particular employment test or practice. Let's use the word practice and not test. Remember, interviews are tests, performance appraisals are tests, although that probably is a little bit different here because that person's already on the job. That causes a disparate impact on the basis of race, color, religion, national origin, etc. And either the respondent fails to demonstrate, that respondent being the employer, fails to demonstrate that the challenge practice is job related for the position in question and consistent with business necessity. I'll come back to that in a second. Or the respondent refuses to adopt an alternative employment practice. Now, business necessity, the courts have allowed businesses to show that this was a business necessity and doing something different would be too costly. And so if they can show that, then they're okay. The burden of proof is on the employer. To demonstrate disparate impact, either under condition 1 above, show that the disparate impact at employment practice. The plaintiff must identify a specific practice and show it results in a significantly higher percentage of a protected class being rejected for employment, placement, or promotion. Now, let's just for the sake here for a few minutes, use a critical eye to examine the court's ruling. Possessing a high school degree is neutral. Well, yeah, it is, but not if you're where Griggs was from. Is taking a standardized test neutral? Well, you could argue that that's possible, but that argument fails when the test is not job related. The following is another potential neutral employment practice. A company that makes specialized electrical parts for aircraft engines recruits word of mouth. With Allen Bradley, we talked about this before. They only hire people who are referred by current employees. That type of practice may be discriminatory because workplace is populated by whites only. That's a test. We have to remember that's a test. It's a practice, a test. Organizations should hire the best available candidates, ensure hiring practices cast a wide net. Now, there was another case of disparate treatment, but I want to, before we get to that, talk about sexual harassment because that is the case that you're going to talk about today. But we need to think about this because there's some underlying questions that are in that case. So need to look at, and then when that case is, I will respond to each of you as I normally do, but I will give you the full court ruling, which you can find in the forum section. Right now it's turned off. You can't read that. I'll turn that on after next Wednesday. This is harassment comes when an employee, harassment, not sexual, harassment comes when an employee is persistently annoyed or alarmed or concerned about their well-being because of actions by others or is in a hostile environment. Most cases, however, involve behavior directed at someone because of their gender, and that's what's known as sexual harassment. This is what it's classified as. Submission to such conduct is explicitly or implicitly a term or condition of employment or promotion or other benefit that's known as quid pro quo. Submission or rejection is basis of employment decisions. Again, quid pro quo. Conduct as a purpose to unreasonably interfere. That's sexual harassment itself. It's not quid pro quo. Quid pro quo, a Latin term meaning this for that. I think these folks give a little bit something different than that. Something for something, they call it that. Not the way I learned it when I took Latin in high school many years ago. What are we talking about that? And then the hostile, I'm not going to spend a lot of time in the hostile work environment. These come from comments and behavior of people that cause a reasonable person to be concerned about their well-being and it upsets the working environment and things of that nature. Notice here this last statement. The victim doesn't have to show that comments made them completely incapable of performing tasks, only that the environment itself was poisonous and it had an impact on their well-being. So I don't have to show if somebody's harassing me a hostile work environment. I don't have to show that I can't do my work. What I have to show is that it's causing me problems. And by the way, I think the case is mentioned in the text. The Supreme Court has ruled that sexual harassment itself does not have to necessarily be one gender to the other. It can be based upon same gender to same gender. That was in Sundowner. I can't remember what the rest, I think Sundowner case. I can't remember what the other part of the respondent is. Now, I have an interesting case here I want to discuss with you, which also falls into disparate impact. And this is a case that I find interesting simply because most people wouldn't even consider bringing it before the light of day. And this happened in a case with Hooters. It's much easier to understand disparate impact. Excuse me. This is a case of disparate treatment, not disparate impact. It's much easier to understand when we use this Hooters case. I forgot to read my notes, and I apologize for that. Hooters, as you know, well, let's go back here. We know how disparate treatment is. Disparate treatment is treating some people differently we treat others. When we do that, we've clearly said that our practice is discriminatory. Now, I will cop a plea here and say that perhaps the offending organization doesn't really say that. They don't really mean to say that, but they do that. And that's what this disparate treatment comes under. So Hooters, as we know, employs females attired in. Now, I want to tell you here, first of all, this is a disclaimer. I have never been in a Hooters in my life. I only know of Hooters from what I hear from people who have been in there and what I have seen. they employ female wait staff who wear rather tight T-shirts and wear shorts, and that's their wait staff. Some years ago, Hooters openly denied men the opportunity to apply for server positions. So here we are, disparate treatment. Why is it that a man can't have a waitstaff job in Hooters? Now, you could make a case of saying, and I could even hear some of you saying, and I may have said it myself, why would a man want a job waiting tables at Hooters? He probably could go someplace else. He could go to an Outback, or he could go to some other establishment and probably make as much money or more. Why does he want to get in Hooters and compete with women? I don't know. I can't answer that. So they openly denied men the opportunity. Notice that, the opportunity to apply. And several men complained to the Equal Employment Opportunity Commission, and the commission brought legal action against Hooters. Classic case of treating different classes of people differently. The case was settled without court action. The settlement required Hooters to give men the opportunity to apply for positions that were viewed as similar to those of the female waitstaff. Now, we could say that what the court did here was one of two things, depending upon how you want to view this. That the court came up with a Solomon-esque decision, allowing Hooters to keep its female waitstaff, scantily attired, my term, and allow men to apply for a similar position, or a position that was viewed having similar responsibilities, etc., as the waitstaff. Or you could say the court copped out and allowed Hooters to keep its all-female waitstaff. Well, I think if we look at this case fairly logically, we would see that by and large, men really didn't want that position. They just wanted to have the opportunity to apply for it. Now, I could be wrong. I'm trying to use a little logic here. And my logic may be a little faulty. But I think the court probably found what it considered was a reasonable solution to a situation that probably was not going to be easily resolved. Now, the court simply could have said to Hooters, no, you have to hire men, and then that probably would have changed Hooters' clientele. It would have changed their business practice, et cetera, and it may not have been a wise decision. It might have been the right decision, but it might have been a wise decision. So here we have the case was settled without going to court. Probably best for all sides considered that it didn't go to court. The source on this, by the way, is anonymous restaurant chain to resist on hiring men that appeared in the New York Times on November 16, 1995. And then the subsequent source, Hooters settled suit by men denied jobs, also appeared in the New York Times on page 20 on October the 1st, 1997. By the way, this is cited in the text that I use to supplement this course, Stewart and Brown, 2009 Human Resource Management Linking Strategy to Practice, and published by John Wiley. I use this case as an obvious example of disparate treatment. We often don't think about these incidents because what's taking place is not apparent. Years ago, when Playboy clubs were running around high, wide, and handsome, they employed Playboy bunnies who were more scantily dressed than the Hooters waitstaff. But there were no men there, not as bunnies. their men had other positions of employment. I don't know that anybody would have wanted to apply for that, but they may have. The only way to avoid this type of discrimination, as we talked about before, is to use a bona fide occupational qualification, BFOQ. And you would have to do that when you constructed a job analysis. Hooters would have been hard-pressed in trying to either develop a BFOQ for its wait staff or even to use that as a defense. Good examples of BFOQ based on gender would be in the entertainment industry. Male acting roles are usually required to be performed by males, and the same applies to female roles being performed by female actors. Of course, this was not the case in Shakespeare's time, and I had the opportunity a few years ago to see a play in the Globe Theatre in London. And they put Shakespeare on, as Shakespeare was put on back in the late 1500s and early 1600s, and even later than that. And all the performers in the play were male actors. So we didn't see any female actors in that play whatsoever. But I was staying true to what Shakespeare was. I'm not saying Shakespeare is right, wrong, or indifferent, but that's what we had. Now, I want to conclude this by saying that regardless of the piece of staffing legislation or the court decision you choose, you must evaluate its impact on organizations' hiring practices. So when you're writing your assignment, please look at what the impact. How did they change that? When Griggs is pretty obvious. I ask that you don't use Griggs because I use that as my example. But there are other ones in there. There are many other ones in there. And you can show how hiring practices were changed or what they did to ensure that sexual harassment wasn't there. And by the way, that's a hiring practice, or it's a workforce practice, it's a staffing practice, or it can be. What changed the hiring practice for organizations after the law or legislation was enacted or the court decision was rendered? You may wish to, and I encourage you to use an internet search engine to help formulate your response. But I do caution you to please make sure that your work is original and that you use proper citations as may be necessary. And finally, please read the sexual harassment case listed in the assignments section for week 3. Post your responses in the forum section. I think that you'll find that Torres versus Pisano case very interesting to read. There is a lot of I was going to say innuendo in that case, but that's not correct. There probably is some, but there's some byplay here in this particular case, and so you need to look at it with a critical eye, answer it critically. Don't answer it at first blush. Very interesting case to me, and I think it was a very interesting decision rendered by the court. So I think that it probably is as good a case of sexual harassment as you're going to see. That is a little different in some cases than some that you might see. So we are at 6:15. We have spent the last 2 academic hours discussing legal compliance, federal court cases, etc. I thank you for your attention. I will have this uploaded tomorrow, and you'll be able to see it at your convenience. Thank you very much for your attention. Good evening.